Did you know that there's an entire strategy that goes into doing jury selection in a civil lawsuit here in New York? You want to learn why I say that? Come join me for a moment as I share with you some great information and give you an inside look at what goes through an attorney's mind when they go in to pick a jury. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So let's say it's a medical malpractice trial, and now we are asked to go pick a jury. 6 members of the community that we need to be fair and impartial who are willing to judge this case to decide whether we are more likely right than wrong, that what we are claiming is true. And now we have the opportunity to talk to 25 to 30 people that are brought into a room. My adversaries are present, and now I have a chance to talk to them and ask them questions about how they feel. Hey, Mrs. Jones, are you a little closer to the people who believe that it's okay to bring a lawsuit against a doctor if they feel something was done wrong? Or do you believe that people should never bring a lawsuit? And now we get to explore their opinions and their feelings. Mrs. Jones, do you believe that a doctor can do no wrong? And now I get to hear from her as to what she thinks. Now, there are strategies that go into jury selection in terms of the questions that I can ask and the information that I'm going to obtain. Now, why is that important? It's important because each attorney has only 3 opportunities in which to remove jurors that they don't like. And we don't have to give a reason to anybody if we're going to be using any one of those 3 opportunities. That's known legally as peremptory challenges. And what happens if I've used up all of the opportunities to remove jurors whom I don't like, who I think will hurt our case? Well, now I'm talking to juror number 4, and he tells me some things that really bother me. He tells me he can't be fair, but at the same time he tells me he can be fair. He tells me something happened to him in the past that's very similar, but he has feelings for the doctor. Well, you know what? Now he creates a conflict. So what can I do if I want to get this potential juror off of this panel? Well, now I have to do something called a challenge for cause. Now I have to explain to the judge what my questions were and what this potential juror was answering. And now I have to explain to the judge why this guy legally should not be allowed to sit on this panel. There's no way he can be fair. There's no way he can be impartial. And based upon his answers, it's clear and evident that there's no way he can be fair and impartial. And now the judge will listen to the defense attorney, and the judge will then make a decision about whether or not to excuse this particular juror. That's how an attorney tries to get other jurors off of the panel, by using what's known as a challenge for cause. There has to be some clear reason that the juror has given to us that does not make him the right juror for our case. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.